Honourable Leanne Dalzell.
Mr Speaker, I believe that a very good process was begun by the former Minister of Justice, the Honourable Simon Power, with respect to instigating the Family Court review. But that process has somehow got sidetracked into this efficiency drive, and it's become a drive to save money. And the concerns that I believe that we're raising on this side of the House are that, in fact, that may have unintended consequences, but so significant that they could place at risk some of the people that we all in this House seek to protect. I want to read out 12 key points that were set out in a very important document, and I want to explain where that fits within the context of the legislation that we're debating this evening. That the Family Court and its processes warrant review and reform is unarguable. Everybody agrees with that. The problems of cost, delays, inefficiencies and ineffectiveness are easy to identify. The Family Court of 2011 is not what was envisaged by the Beattie Commission, and that model has never been effectively implemented. There is a fundamental confusion of roles. Is the Family Court a court or a social agency? This confusion inhibits a rational examination of the Family Court. The Care of Children Act 2004 is the most significant source of pressure on the court. That is where the focus of this review properly lies. I would actually add into that the Child Support Act, because I believe it's a silent player in all of the dynamics that occur in a breakdown of a relationship involving children. Number 6, reform does not need to jeopardise those who can be properly categorised as vulnerable. The role of the state in private disputes needs to be revisited. And when I use the word revisited, I would say re-examined. There needs to be a better understanding of what the role of the state is in the settlement of private disputes, because there is a public interest, and I want to come back to the public good when I go through the regulatory impact statement, which I, of course, want to do. Reform should be governed by an overarching strategy. That's a very good idea, to have an overarching strategy when considering reform in such a fundamental area of the law. Focusing solely on economic fiscal factors may give rise to unintended negative consequences, and I really do urge the House to think very carefully about that. An effective, simple and accessible pre-filing, pre-court process is called for. Use of the court as a court of law should be a last resort. And where use of the court as a court of law is called for, efficiencies are available in the form of the laws of evidence, family court rules, case management programs and assured competencies. These may need refinement, but the tools are already there. Less, not more, process is called for. And this was the Family Law Section Symposium held in June last year, held by the Family Law Section of the New Zealand Law Society. And I believe that the lawyers of our country have actually come under some unfair criticism from the government tonight in relation to this particular piece of legislation. All of the advocacy that they have put into this area of law has been firmly founded on principle, in my view, and I think we should be very grateful that they took the opportunity to bring together some of the greatest legal minds in this country, and also some of the people involved in counselling and in the social work fields, brought them together in order to debate the fundamental issues that underpin the Family Court review. So a very good process, Mr Speaker, unfortunately now thwarted by an efficiency-driven government, which leads me to the regulatory impact statement and the agency disclosure statement at the beginning, prepared by the Ministry of Justice. And one of the members opposite spoke of the statement around consultation, but before I get to the consultation, I just want to highlight for the House the constraints that were highlighted in the report. Given the overall fiscal situation, urgent steps must be taken to lower the cost of the current justice system, while at the same time delivering more effective and efficient court services. This means the options we have considered must be able to be implemented quickly. So the driver is cost. that is it, and I think that the House should be very wary of the driver being cost when we are talking about such a major reform. And so for the sake of speed and cost and efficiency, that has meant that they have been prepared to accept gaps and uncertainties in the policy analysis and a consultation period. And I want to continue to read the section that one of the colleagues on the other side of the House, where he talked about extensive consultation, meeting with stakeholders, a public consultation paper and an online questionnaire for court users. He went full stop there. Let me read the rest of the sentence. However, because of the time frame, there has been limited opportunity to discuss the final proposals with stakeholders. There will be an opportunity for consultation at the Select Committee stage of the future legislation. Can I just remind this House that consultation is not receiving a submission in a public hearing. That isn't consultation. It cannot be regarded as even a substitute for consultation. We have had hearings in front of select committees where we've told submitters that because they're an individual, they have 5 minutes to present their case, and could they leave a little bit of time for questions. And we've had major organisations given 10 minutes, maybe 15 minutes, and sometimes we stretch to 20 minutes, and usually the Law Society on a bill like this would get half an hour. But that is not consultation. That is about persuading the numbers of members of Parliament that are sitting there and the officials that are advising them and supporting them that their case has some merit. And I want to remind the House what the Minister has said in introducing this legislation. And I'm quoting now from Judith Collins, who is the Minister in whose name the bill is introduced. Our reforms will ensure that the family court renews its focus towards those who need it most, said Collins. The court must put the needs of children first rather than those of private couples with relationship issues. And that's the fundamental flaw, Mr. Speaker, in her thinking, and it's the fundamental flaw in the legislation, and it explains about how we can privatise the cost. Because we can say that this is just about the private interests of couples. But can I say that the speedy, sensitive, judicious settlement of disputes that involve the care of our children actually has a huge public interest that must be met, and it is not met by a piece of legislation that will drive the cost into this family dispute resolution service. A solution that we support. We support the concept of family dispute resolution. Can I just say what the advisory group said in response? They were not consulted on the proposal that the parties would have to meet the full cost of family dispute resolution unless they were exempt on the basis that they were eligible for legal aid. And this is their quote: "Our recommendations were made on the presumption that parties would make a contribution to costs of professional services," so that's the professional to the lawyers, "but on the basis FDR would be predominantly funded by the ministry." You know, over $900, and it's a cost to be split between warring parties in some instances. If they agree, and what if they don't agree? And how is that going to resolve things? I think that we have to think very carefully about the impact of this. And I just want the House to hear another thing from the group. Hidden power and control dynamics in relationships will mean parents are intimidated into agreeing to settlements which disadvantage them or their children. Also, there will be delays as the courts will not have the proper information needed for making decisions, with the result that the conflict between parties will intensify, and those cases where a parent is consciously alienating a child from the other parent will be harder to resolve. Mr. Speaker, that's the problem, is that these hidden dynamics in these private relationships only get exposed when there are people independently acting in the interests of children. And so I believe very strongly that we need to proceed with great caution, but we will not be supporting this bill to the Select Committee, and we will have to see significant change before we would change our mind further.
I call Tim